Good afternoon, everybody. As I think you know, my name's Edward Denehan, and it's my pleasure yet again to advance to the Society a property lecture this afternoon. I think it's the ninth year that I've done it, and every year I can hear you say, "Not him again," and every time I do it, I think, "Oh, never again." But here we are. Um, I apologise that it's coinciding with the first British quarterfinalist, male quarterfinalist at Wimbledon since I think 2016. But there you go. I'm sure we'll get through into the semi-final and we can all watch it there. We've got an hour and a half together, and I think that possibly the best way forward is just to push on through. For the purposes of this afternoon, I've produced 5 papers, which I'll mention in a minute. I don't know if they've been distributed amongst the delegates yet, but they have been made available to the Society. So if you haven't got them, you will. I'm not going to speak to every word that I've written because that would take far too long and would be tedious beyond description. But I'll just pick out from those papers the points that I think are of most interest. I like to think that the papers I produce are full in themselves, and so they can be referred to going forward if one has a problem or an issue or a question arising in the subject matter of the paper. The papers that I prepared for this afternoon's lecture are first a survey of the Commercial Rent Coronavirus Act 2022, something new. Then a paper about waiver of forfeiture. I've chosen that because I consistently come across doubts and mistakes, dare I say it, with the law of waiver of forfeiture, as I've called it, and therefore it's worth a revisit. Then a short paper on tenants' repairing obligations. The fourth paper is a brief survey on claims under Section 84(2) of the Law of Property Act 1925, one of my favourite provisions in the Law of Property Act, and something I do an awful lot of, and it's a very useful provision, which is perhaps not as well known as it should be. And finally, I've produced a paper concerning surrender of leases, again, something that arises surprisingly frequently in my practice. So those are the papers I'm going to speak to, and that's the order I'm going to speak to them. So the first paper is the Commercial Rent Coronavirus Act 2022. I'm going to keep saying 2020, forgive me, it's 2022. And for the vast majority of purposes, it came into force on the 24th of March of 2022. That's an important date, one, because the Act came into force, but there's a certain time limit, which I'll speak to in a minute, which is measured by the commencement of the Act, which is an important time limit. So the 24th of March, 2022 is when the Act came into force. It extends to the entirety of England and Wales. Some of its provisions also apply to Scotland and Northern Ireland. Some apply to England and Wales and Scotland only. We're concerned with England and Wales, albeit that there are differences because the devolved government in Wales had its own powers to implement coronavirus restrictions, which we used to see on the news all the time. So they're not comparable with the restrictions in the UK throughout. There's slightly different dates. I won't speak to the Welsh provision, if I may, with no disrespect, but they're all covered in the paper. Now, the Act is divided into 3 parts, 3 substantial parts with some schedules. The first part 1, it's called, is concerned with some basic definitions and expressions, and we'll look at that in a second. Part 2 is concerned with arbitration in respect of disputes between landlords and tenants concerning unpaid rent. And part 3 is concerned with restrictions on certain rights and remedies that a landlord might otherwise have against tenants who fail to pay their rent. We'll look at each in turn, starting with part 1. As I say, that contains a number of definitions and expressions. Some of them are fairly familiar in the sense that we've heard of the words, but they are given in the Act in many cases extended meanings, which are somewhat surprising to us humble property lawyers. And then there are certain definitions and expressions which are unique and appear for the first time in the 2022 Act. And they're a bit of a tongue twister, right? At least I find them to be, so bear with me. The first definition I want to mention is that of business tenancies. The Act only applies to business tenancies, and essentially they are tenancies to which Part 2 of the Landlord and Tenant Act 1954 applies. So if there's a dispute between a residential landlord or a tenancy that doesn't fall within Part 2 of the 54 Act, nothing in the 2022 Act applies, and therefore the landlord can pursue the tenant for arrears of service charges, ground rent, whatever it is, with impunity, or if not with impunity, then certainly with no restrictions imposed by the 2022 Act. I make the point in the paper, which is sometimes forgotten, that merely because the tenancy of these business premises have been, Part 2, forgive me, has been excluded in relation to that tenancy, doesn't take it outside the 2022 Act. I say that because you'll recall that when one agrees with the tenant, if one's acting for a landlord, to exclude the provisions of Part 2 and goes through the procedure that one has to do to achieve that under Section 38 of the 1954 Act, you don't exclude Part 2, one simply excludes the operation of Section 24 to 28 of the 1954 Act. So a tenancy in respect of which those sections have been excluded is a business tenancy within Part 2 if it satisfies the definition of a business tenancy, namely a tenancy of premises which are occupied by the tenant for the purposes of business carried on by him or her, or for those or other purposes. So don't think merely because 24 to 28 has been excluded that the 2022 Act doesn't apply. The next definition I want to refer to is the definition of rent in the Act. It's an amount consisting of one or more of 3 types of payment. There's an amount payable by the tenant to the landlord under the tenancy for possession and use of the premises comprised in the tenancy, whether described as rent or otherwise. So that would be what, without thinking about it too deeply, we would call rent, properly so called. But the word rent is defined in the 2022 Act to include service charges that are payable by the tenant to the landlord, and also interest on any unpaid amount of rent or service charges. And service charges has a wide definition. It includes insurance costs, recovery costs, as wide as it can possibly be. So when the Act refers to rent, it is not simply referring to the rack rent that might be payable under this business tenancy. An amount drawn down by a landlord from a tenant's deposit to meet the whole or part of a debt is treated as unpaid rent from the tenant to the landlord under the Act. The next definition I want to trouble you with is something called a protected rent debt. And And that's a debt under a business tenancy consisting of unpaid protected rent. And this is a key definition. Protected rent is rent due under the business tenancy if the tenancy was adversely affected by coronavirus and the rent is attributable to a period of occupation by the tenant for or for a period within the protected period applying to the tenancy. So unless the rent debt is one that's adversely affected by coronavirus and occurred or accrued during the protected period, the 2022 Act has no application. That adversely affected by coronavirus is defined as well, Section 3, and that provides that a tenancy will be so affected if during the relevant period, the whole or part of the business carried on by the tenant from the premises or the whole of the premises was of a description subject to a closure requirement. So we'll look at what a closure requirement is in a minute. So the tenancy will be affected by coronavirus if, for example, and we'll remember it, the business of the tenant, whatever that business might be, couldn't be carried on because of some restriction, or the premises had to close because of some restriction. They're not necessarily the same thing. And the closure requirement is defined as well. And a closure requirement means a requirement imposed by coronavirus regulation, which involved closing of the premises or part of the premises, or closing the business or part of a business. So you remember there were certain restrictions on selling certain goods and so on and so forth. So that would be caught by this definition. The relevant period is a period on or after 2 p.m. on the 21st of March 2020 and ending on the stroke between 11:55 and 59 seconds and noon on the 18th of July 2021 for English business tenancies. So that's what the relevant period is. The protected period in relation to a business tenancy adversely affected by coronavirus is the period beginning on the 21st of March 2020 and ending on the 18th, essentially on the 18th of July 2021. So that's the important date, or that's the important period. It's only debts that accrue during that period which will be subject to the substantive provisions of the Act. So to give you them again, it's the 21st of March 2020 to the 18th of July 2021. Different dates apply to Wales, as I've touched upon above. So as I say in the paper, the maximum protection period in England is 21st of March to the 18th of July. There's an expression, namely the matter of relief from payment, and that is defined as meaning a dispute as to whether a protected rent debt of any amount exists, and if so, whether the tenant should be given relief from the payment of that debt, and if so, what relief. And the final definition, I think it's the final definition I need to trouble you with, is relief from payment. Relief from payment in relation to a protected debt means any one of the following: writing off the entire debt or part of the debt, giving the tenant time to pay the debt or part of the debt, and reducing, including to zero, any interest that would otherwise be payable by the tenant under the terms of the tenancy. So essentially what the part 2 does, and we'll come on to that right now, is to have the question of relief from payment arbitrated. And as I say, part 2 of the Act is concerned with arbitration. And it's made clear in the Act that there's nothing in the Act which prevents the parties agreeing how what would otherwise be a protected rent debt is dealt with as between the two of them. So if the parties agree, that is fine, and there is no compelling, it's not an arbitrary one, sorry, it's not arbitrary, it's not compulsory for any dispute on that to be arbitrated. Having said that, of course, as I'll explain procedurally, it's open to one party to a tenancy to make a reference to arbitration, and that has certain consequences. Sections 7 and 8 of the Act are concerned with the approval and function of arbitration bodies. Now, I don't want to spend too much time on that because it's essentially administratively putting in place the structure in which these arbitrations can take place. And seven bodies or 8 bodies have, or 7 bodies, forgive me, have been approved as arbitration bodies, and they include the Chartered Institute of Arbitrators, the Royal Institution of Chartered Surveyors, although on the government website, the name of the Royal Institution is incorrectly identified, and indeed Falcon Chambers, the barristers' chambers, well-known property barristers' chambers, they are a approved arbitration body. And the functions of these bodies is to, amongst other things, keep a list of approved arbitrators. So if a landlord and or a tenant wishes to have make a reference to arbitration, they can apply to one of these approved bodies, and the approved body will give a list of names of arbitrators who are holding themselves out as being suitably qualified to do this sort of thing, and will indeed appoint an arbitrator if the parties can't agree as between themselves who the arbitrator should be. An important point is that there is a limited period for making a reference to arbitration, and it is 6 months beginning on the date on which the Act was passed. And that's why when I said a little while ago that the date of commencement of the Act, 21st of March 2022, was important. So a reference to arbitration must be given, or must be made, forgive me, before the 24th of September 2022. After that, it's all too late. The Secretary of State can extend that period. I've been unable to establish at this stage whether that has happened. In other words, it hasn't happened. So there's 6 months in which to make a reference, otherwise the shutters come down. There's certain requirements for making a reference. They must be satisfied before the landlord or tenant can make a reference under Section 9 of the 2022 Act. The first is the party who wants to make a reference must inform the other person of that, and then they're given 14 days from that notice before a reference can be made. This allows the other side to respond and say, perhaps we can sort it out ourselves, and so on and so forth. It's a tedious sort of pre-action procedure, which is described in the Act and set out in the papers. Once those steps have been taken, the referring party must produce something called a formal proposal. And that is essentially the proposal by the party making the reference for the treatment of the protected rent debt. And any proposal produced must be accompanied by supporting evidence. And what that will involve, for example, if the reference is made by a tenant, the tenant will have to produce evidence to show the impact the coronavirus restrictions have had on the tenant's business in respect of the protected period. So, for example, if the business simply couldn't be carried on because it had to close, that would have an obvious effect. But the tenant would have to show, I would suggest, the impact it would have on the business in terms of pounds and pence. And therefore that evidence must be produced. The section 13 sets out the awards that they're open to the arbitrator once there has been a reference. He's or she's first got to determine that the parties have not by agreement resolved the matter. If they have, then he kicks it out or she kicks it out. If the tenancy is not a business tenancy, it's kicked out or dismissed, forgive me. And if there's no protected debt, the award that's made is dismissing the reference. But would like to think that those basic requirements will be satisfied. If after having assessed the viability of the tenant's business, the arbitrator determines that at the time of the assessment, the business is not viable and would not be viable even if the tenant were to be given relief for the payment, again, the arbitrator must dismiss the reference. So this is not a procedure which is designed to save failing businesses in any event. If after carrying out that assessment, the arbitrator determines that the business is viable or would become viable if the tenant received relief from payment of any kind, the arbitrator must resolve the matter of relief from payment of the protected debt by considering whether the tenant should receive any relief, and if so, what, and making an award in accordance with section 14. The important section in terms of how the arbitrator deals with this is section 15, which is entitled Arbitrator's Principles. It describes the principles the arbitrator must apply when considering what award to make on a reference under Part 2. It's spelled out in section 15.1 that the primary principle of an award is the preservation, in a case of falling within 13.4, or the restoration and preservation in a case falling within 13.4b, the viability of the business of the tenant so far as that consistent with the preservation of the landlord's insolvency. So there's going to have to be a balancing up between the impact of an award on the landlord's insolvency and the viability of the tenant's business. In considering the viability of the tenant's business and the landlord's solvency for these purposes, the arbitrator must disregard anything done by the tenant or the landlord with a view to manipulating their financial affairs so as to improve their position. Most obviously, for the purposes of section 15, the landlord is solvent unless the landlord is or is likely to become unable to pay its debts as they fall due. Section 16 is concerned with the assessment of viability and solvency. And when carrying out that assessment, the arbitrator must, so far as known, have regard to the following: the assets and liability of the tenant, including any other tenancies to which the tenant is a party, the previous rental payments made under the business tenancy from the tenant to the landlord, the impact of the coronavirus on the business of the tenant, and any other information as to the financial position of the tenant which the arbitrator considers appropriate. In assessing the solvency of the arbitrator must have regard to the following: the assets and liabilities of the landlord, including other tenancies to which the landlord is a party, any other information relating to the financial position of the landlord as the arbitrator considers appropriate. In carrying out the assessment of the viability and the solvency, the arbitrator mustn't have regard to the possibility that the landlord or the tenant can borrow money or restructure its business. The section 17 makes provisions for the timing of the award, and I won't trouble you with that. It says you've got to get on with it. Section 18 provides that the award must be published unless together with the reasons for making the award. However, the landlord is empowered to exclude confidential information from anything published, unless the person whose information is notifies the arbitrator that he or she doesn't mind if the confidential information is published. Confidential information is defined as being commercial information relating to a party, the disclosure of which would or might significantly harm the legitimate business interests of the party, information relating to the private affairs of an individual, the disclosure which might significantly harm that individual's interests. And one doesn't have to be too commercially minded to understand that if one has to put before an arbitrator evidence of the viability of a business or the solvency of a landlord, that could be hugely sensitive. So I rather suspect that no confidential information will be published as part of any award. One wonders why it's provided that the awards have to be published in any event. Perhaps it's thought that there might be a body of precedents which other arbitrators can follow if the awards are published. Section 19, yes, Section 19 of the Act is concerned with arbitration fees. And again, that's a procedural matter set out in detail, which I won't speak to. Section 20 provides that there can be oral hearings at the request of one or other parties. And if the request is made, the landlord must have an oral hearing. It's not in the hands of the arbitrator to make that decision. And perhaps for the same reason as mentioned about the publication of the awards, any hearings must be held in public unless the parties agree otherwise. I can't imagine for the life of me why anybody would want to wash this laundry, financial laundry, in public. Having said that, I can't imagine, say, perhaps if the landlord and or the tenant is of a body of some interest, that any member of the public would want to spend time sitting in such an arbitration. The fees for an oral hearing have to be paid in advance. The Secretary of State may publish guidance as to the operation of the arbitrations under Part 2, and indeed have done so. If you simply search on the government website for guidance under the Commercial Rent Coronavirus Act 2022, you'll find it. I have a copy of it. It's very long, and I'm not sure what guidance it's got in it other than setting out what the Act says. But nevertheless, it's written in a more palatable fashion than the Act itself, which is particularly turgid, as you can imagine from my presentation of its provisions thus far. And that was the interesting bit. There are modifications to the Arbitration Act 1996 set out in Schedule 1, again, the details of which I needn't trouble you with. Perhaps of more immediate significance is Part 3, which creates a moratorium in respect of certain remedies and insolvency arrangements. Now, I know we all have to be, to a certain degree, insolvency lawyers, but I certainly don't hold myself out as having a particular knowledge of such matters. So I'm going to speak only to a moratorium on certain remedies that are available to a landlord, as this is a property seminar. The moratorium on insolvency arrangements is essentially a moratorium in making somebody a bankrupt or winding up the tenant. That's too simple, but that's the effect of it. It's to limit what the landlord can do. The Section 23 of the Act explains that Schedule 2 contains provisions preventing a landlord who is owed a protected rent debt, it's only the protected rent debt, from using certain remedies in relation to or on the basis of that debt during the moratorium period. And the remedies that are restricted are making a debt claim in civil proceedings, can't sue for the money. Using commercial rent arrears recovery power, the modern distress, enforcing a right of re-entry or forfeiture, which is significant, and using a tenant's deposit. I've recently been instructed in a case involving a restaurant on the Edgware Road, where the landlord has re-entered. The business has been, so I'm told, decimated, and I can believe decimated by the coronavirus, and it's in a parade of restaurants which have all been closed down, which has brought social problems with rough sleepers and so on and so forth. And this rather aggressive landlord has re-entered to forfeit the lease. And my client, not to a degree that persuades me it's correct at the moment, says that all the rent arrears that the landlord could possibly rely upon in order to forfeit the lease, and that's the only ground of forfeiture which has been relied upon, is a protected rent debt. So if that's right, then the landlord's forfeiture has been unlawful. That's to be decided. Of course, if there is other debts that are not protected rent debts as defined within the 2022 Act, then the rights of the landlord and his or her remedies are available. Even if there's a protected rent debt, they have to put that to one side, but can rely upon any other debt. And as I've identified, the protected period is really rather modest, just over a year. This is not the order in which they appear, but I'm dealing with them in this order. Restrictions on re-entry or forfeiture. That's paragraph 5 of Schedule 2 to the Act. And it provides that during what's called the moratorium period for the protected debt, enforcement by action or otherwise of a right of re-entry or forfeiture cannot be exercised by the landlord. That familiar formula, by action or otherwise, makes it perfectly clear that it's not just claim for possession by court proceedings on the ground that the lease has been forfeit, which is prevented by these provisions, but also peaceful re-entry in respect of premises where that means of forfeiture is still available, for the most part, business tenancies only or commercial premises only. The moratorium period is an important definition that's set out in section 23(2). It's the period beginning on the day when the Act was passed and ending where the matter of relief from payment of protected rent debt is not referred to arbitration. The period of 6 months beginning with that date and the last date of that period, so that 6 month period, where the matter is referred to arbitration with the day on which the arbitration concludes. No conduct on the part of the landlord during the moratorium period, other than by giving express waiver in writing, is regarded as waiving the right of re-entry or forfeiture under the business tenancy for non-payment of rent. We're looking at waiver of forfeiture in a short while. They think of everything for the purposes of determining the ground of opposition contained in section 31B of the 1954 Act. You will recall that under section 30, subsection 1, a landlord can oppose an application for a new tenancy under the part 2 of the 54 Act, or indeed apply for an order determining the tenancy on certain grounds. And 31B is that the tenant has persistently delayed in paying rent and therefore ought not to be granted a new tenancy. For the purposes of any debate between the landlord and the tenant about the applicability of section 31B, any failure to pay a debt during the moratorium period is to be disregarded. So the tenant gets a free pass in respect of the moratorium period. You remember that under 31B, the landlord doesn't have to show that there is a rent arrears at the date of the application for a new tenancy or the date of the application for determine termination order, simply got to show that the tenant's been a bad payer. But in assessing whether the tenant is a bad payer or not, one simply disregards, or the court will disregard, debts not paid during, or rent debts not paid during the moratorium period. The second restriction, which is prescribed in paragraph 2 of Schedule 2, simply provides that the landlord can't, during the moratorium period for a debt, make a debt claim to enforce the protected debt. And a debt claim means a claim to enforce a debt in civil proceedings. That's pretty straightforward, I would suggest. Paragraph 9 restricts the tenant, the landlord's, sorry, this is the tenant's deposit. Paragraph 9 of Schedule 2 applies where there's a tenancy deposit available to the landlord for the purposes of applying towards the unpaid debt. The landlord can't, during the moratorium period for the debt, recover the debt from the tenancy deposit. And if the landlord has unlawfully dipped into the deposit, notwithstanding anything that says in the deposit deed, the tenant needn't top up the deposit if the landlord's done that. Finally, I can say that during the moratorium period, the landlord can't rely upon the commercial rent recovery power to recover the debt. That is a quick run through. I read in of the 2022 Act. I don't know how popular this is going to be. I read on social media, that business social media recently, that LinkedIn, where lawyers spend endless hours saying how wonderful they are and how they've been promoted and so on and so forth. And barrister in Falcon Chambers, who's obviously been approved by the Falcon Chambers arbitration body to carry out or to be the arbitrator under the Part 2 of the 2022 Act. And she has given directions for disclosure and so on and so forth, and opines that, to her knowledge, it's the first arbitration that's been got that far under the 2022 Act. And that was, if not earlier this week, it was only Tuesday, it was last week. So I don't know, we're now July, so we've only got a couple of months before the shutters come down on that. So I'm as confident as I can be that the paper that I produce will provide an almost comprehensive account of the relevant provisions of the 2022 Act. And perhaps may I suggest, I won't put it on LinkedIn, I suggest a good starting point rather than delving into the Act itself or the government guidance, which I referred to a little earlier. Now for something completely different, although we have touched upon it very briefly in the first paper, and it's waiver of forfeiture. Now, as I think I mentioned when we started, that I'm troubling you with this because on the one hand, I think that the rules are fairly straightforward, but it still causes some concern to certain clients of mine, and no doubt they're reflective of others, other lawyers in the property world, and therefore it's worth revisiting. The title waiver of forfeiture is in one sense misleading, because once a forfeiture has occurred, it can't be waived. Once that a lease has been forfeited, it's been forfeited. That's the end of it, and no act of the landlord can resurrect the lease. Of course, the tenant can apply for relief from forfeiture, but that's a different matter. And of course, the parties can agree that the tenant remain in the premises under some new arrangement, but that will be a new arrangement. So waiver of forfeiture is the shorthand that we use, but it's not wholly accurate. as is well known, whether a landlord who has the right to forfeit a lease does forfeit the lease is entirely a matter for the landlord. Various breaches of covenant give rise to various remedies available to the landlord, and forfeiture is often one of them. But the landlord is not obliged, clearly, to forfeit a lease, and in certain markets, that's the last thing that the landlord wants to do. So the landlord is put to the election of whether he or she forfeits the right, and the waiver of forfeiture is based upon the principle or the doctrine of election, and that is made good by, I make that good by reference to a decision of the House of Lords in this Cameron Ballroom and Zenith Investments case going back to 1971, where Lord Diplock, in clear terms, which I set out in the paper, describes what waiver is in this context, and he advises us that it's best to call it election. And what the word waiver or election in this context describes is the position where a person, in our case a landlord, is debarred from asserting a substantive right, namely that the lease has come to an end by forfeiture, which would otherwise be available to him, where that landlord, that person, does something which is inconsistent with that right. If the person has the facts or knowledge of the facts which gives rise to the remedy and acts inconsistently with that, then the person with the remedy will not be able to act accordingly. It's important to have in mind the distinction between waiver of the right to forfeit, which is the subject of this paper, and waiver of breach of covenant. They're not the same. If a landlord waives the right to forfeit, it means the landlord cannot exercise that remedy. But it doesn't prevent the landlord from pursuing the other remedies he or she might have against the tenant arising from the tenant's breach of covenant. Most obviously, if a tenant fails to pay the rent and the landlord has waived the right to forfeit, the landlord can still sue for the debt. If the tenant has failed to comply with the repairing obligation, then subject to other restrictions that might apply, the landlord can apply for an order for specific performance and damages, and so on and so forth. Waiving a breach of covenant is something that's far less common and far more difficult to establish. But it's important to have that distinction in mind. What are the ingredients of waiver of the right to forfeit? There are three elements. First, the landlord must have knowledge of the facts and matters to give rise to the right of re-entry. Secondly, there must be an unequivocal recognition of the continuation of the lease by the landlord. And that recognition must be communicated to the tenant. The first two elements, namely the landlord has to have knowledge of the facts and matters that give rise to the remedy, and the unequivocal recognition of the continuation of the lease by the landlord, is supported by a decision back in 1910 of Matthews and Smallwood, and I've set out the relevant sections from the judgment of Mr. Justice Parker in that case in the paper. The third element, namely communication of the recognition to the tenant, is supported by a case called London and County AD Limited and Wilfred Sportsman Limited, a famous forfeiture case from 1971. The context in which the issue arose in that case is unusual and complicated, so I won't trouble you with that. But in the course of the judgment, the judge, Lord Justice Russell, said that the landlord has elected whether to waive forfeiture. It seems to me, he says, that a statement or act by the landlord which is neither communicated to the tenant nor can have any impact on the tenant should not be taken as election to waive the forfeiture. So there must be a communication to the tenant. Dealing with the first element, the landlord's knowledge, there are two elements to this. Namely, the landlord must have knowledge of the facts and matters that give right to the proviso, the exercise of the right to re-entry, namely the tenants in breach of covenant because they haven't paid the rent, or they've failed to repair, or they illegally sublet, or whatever the case may be. And second, the landlord must have knowledge of the right to elect. The first element, namely knowledge of the facts that give rise to the right to forfeit, this is normally the battleground, if there is a battleground. The authorities vary as to precisely what the landlord must know. There's authority to support the proposition that the landlord must know the basic facts. There's other authorities said that the landlord must know all the relevant facts, but it's a matter of fact and degree, in my view. The question is whether, viewed objectively, the landlord had sufficient knowledge of sufficient facts to alert the landlord to the right to exercise the right of re-entry. At one point, I think is very clear, well, I know is very clear from the authorities, is that merely because the landlord has a suspicion that the tenant's in breach of covenant to such an extent or in such a way to allow the landlord to forfeit the lease is not sufficient knowledge. The knowledge need not be personal to the landlord, of course. Any knowledge of a landlord's agent, an employee, or so on and so forth will be imputed to the landlord, and there's cases of caretakers and so on and so forth having knowledge, and so on and so forth. It's not clear whether constructive knowledge is enough. And what I mean by constructive knowledge is where the landlord turns a blind eye. In one case, it was held that was insufficient, and a contrary has been held in another case, the details of which I've put in the paper. Of course, the burden of proving that the landlord had sufficient knowledge is on the tenant who so asserts. As to the second element, namely that the landlord must have knowledge of the right to elect, it's been said that in cases of waiver or forfeiture, common sense prevents a landlord from saying that they didn't know that they had the right to take possession in the event of a breach of covenant on the ground of forfeiture. It might be said that it depends upon the general knowledge and experience of the landlord. I suppose it could be a case where a landlord has got one property and left it all to the lawyers, but it's never going to arise in practice. If a landlord has a tenancy agreement which contains a proviso for re-entry, and of course you can't forfeit unless the tenancy agreement does contain a proviso for re-entry, then he or she will have knowledge of the right to elect. And that, I suggest, is rarely going to be a problem. What is more of a problem is the second element of the ingredients of waiver, namely an unequivocal recognition of the tenancy. There must be some positive act on the part of the landlord. Service of a Section 146 notice is not consistent, an unequivocal recognition of the continuation of the tenancy. It's quite the reverse. The classic example, of course, is the demand or acceptance of rent. The fact that the rent is accepted by mistake, as it were, and it's kept, doesn't prevent there being a waiver. Accepting without prejudice to the landlord's contention doesn't prevent a waiver. Of course, that rent due which accrued before the cause of action to forfeit arose is not, accepting that rent is won't amount to a waiver because that's payable in any event. It's only rent that has accrued due after the right forfeiture has arisen, the acceptance and demanding of which will waive the right to forfeit. You can waive a right by pleading. One claims possession on the ground of forfeiture, but also seeks an injunction to restrain breaches of covenant that will constitute a waiver. The landlord seeks to rely upon covenants in the lease after the forfeiting event, that will also amount to a waiver of the forfeiture. As to the ingredient, third ingredient, namely communication of the election to the tenant, there's no magic in this. The tenant must know that the landlord has acted in a manner which constitutes waiver. How the tenant acquires that knowledge doesn't matter. And again, it's a matter of evidence. Finally, the effect of waiver depends upon the nature of the breach. Where the breach of covenant is a once and for all breach, waiver of the right to forfeit for that breach precludes the landlord forever forfeiting for that breach. In Woodfall, they identify common examples of once and for all breaches, namely failure to pay the rent, unlawful assignment of subletting, failure to carry out repairs by a given date, and unlawful alterations. So if the tenant carries out an unlawful alteration in July, and the landlord waives the right to forfeit, then the right is lost, notwithstanding the alteration remains in place until the landlord seeks to rely upon some other remedy. Similarly, if the tenant fails to pay the rent due on the, where are we now? The June quarter day, no, we've had June, the September quarter day, the landlord can waive that right to forfeit for that failure if it unequivocally acknowledges the continuation of the tenancy, and have to wait for the tenant to fail to pay the December quarter day in order to forfeit the lease. The position is different in respect of continuing breaches of covenant. Where there is a breach of a continuing covenant, a fresh cause of action arises every day. So a failure to repair is a continuing breach of covenant. So the fact that the landlord waives the right to forfeit because it acknowledges the continuation of the tenancy after a given date. If the premises remain out of repair, the landlord can thereafter forfeit. Failure to insure, failing to comply with a user covenant are other examples of for continuing breaches. So every day that the tenant continues to use the premises unlawfully, that will constitute a cause of action for the landlord, and the lease can be forfeited on that ground. I now want to skip to the third paper. I'm going to change the order slightly because I want to address the issue of claims under Section 84(2) of the Law of Property Act 1925. First, because we've been talking about leases for a little while now, and this is something different. I apologize for changing the order. Section 84(2) of the 1925 Act, you might think, well, this has been enforced for nearly 100 years now, so what's new? I can't tell you that there's been some recent cases concerning the operation of Section 84(2), but it is, as I said earlier, a very useful provision, which is perhaps not as well known as it should. Section 84 of the LPA is entitled Power to Discharge or Modify Restrictive Covenants Affecting Land. Despite this title, Section 84(2) does not confer jurisdiction on any court or tribunal to discharge or modify restrictive covenants. That's Section 84(1), where one applies to the upper tribunal for an order to discharge or modify restrictive covenants. Section 84(2) rather confers a discrete jurisdiction on the court, not on the tribunal. And I'm going to read this out because it is important. it provides that the court has power on an application of any person interested to declare whether or not in any particular case any freehold land is or would in any given event be affected by a restriction imposed by any instrument, or B, declare what, upon the true construction of any instrument purporting to impose a restriction, is the nature and extent of the restriction thereby imposed, and whether the same is or would in any given event be enforceable, and if so, by whom. I'll come back to that core provision in a minute, but I mentioned two other provisions of Section 84, which are relevant to claims under Section 84.2. And the first is Section 84.5, which is of particular importance to the operation of a claim under Section 84.2, and which makes it so valuable. And it provides that an order made under Section 84 is binding on all persons, whether ascertained or of full age or capacity, then entitled or thereafter capable of becoming entitled to the benefit of any restriction, which is thereby discharged, modified, or dealt with, and whether such persons are parties to the proceedings or have been served with the proceedings or not. Section 84.6 is of procedural nature, and basically what that says is that an order can be made under Section 84.2, notwithstanding that the instrument, the conveyance, the transfer, whatever it might be, can't be produced, and the court can rely upon such evidence of the instrument as, or of the restriction as it thinks sufficient. Section 84.2 applies to land, whether it's registered or not. And it applies to restrictions imposed both before the 1925 Act came into force and thereafter. Section 84.12 applies Section 84 to certain leasehold restrictions. The lease has got to be for more than 40 years, and 25 years of the term have got to elapse. There's never been a case where somebody's made a claim under Section 84.2 in relation to a leasehold restriction. So we are really talking about restrictions that burden freehold land. Going back to the core provision in Section 84.2, it provides that the court can make declarations. And it can make declarations in respect of three substantive matters: whether the land is or would be in any given event affected by the restriction imposed by the instrument. So it will, second is, what is the true construction of the instrument? What is the nature and extent of the restriction? And whether that restriction will be enforced or could be enforced by somebody, and if so, by whom. Section 84.2 is thus a very useful tool for a landowner whose land is or may be burdened by a restriction to apply to the court for a declaration which essentially clears the title if the claim succeeds. What's significant about Section 84.2 is that it provides express jurisdiction for the court to make a declaration on hypothetical facts. The classic example is the landlord can go to court and say, if I were to build a block of flats on this land, would that constitute a breach of this restriction? Block of flats have not been built. The landlord's not going to build them unless and until it receives a declaration of the court. And nobody's applying for an injunction to stop the landlord building or anything of that nature. So the landlord pops along to court and obtains a declaration to that effect. The landlord can also say, I take the view that building a block of flats, which I want to on this land, doesn't constitute a breach of this restriction, because if you construe it properly, it only restricts commercial premises. So as a matter of construction, can you construe this covenant for me, this restriction for me, court. The landowner might also go to court and say, is there anybody in the world who has the benefit of this covenant? The original covenantee is dead, and the benefit of the covenant hasn't passed with the covenantee's land, and the landowner can apply for a declaration to that effect. Similarly, the landowner can apply to the court for a declaration to say that John Smith or Joan Brown, named individuals, don't have the benefit of the covenant or can't otherwise enforce it. So that's an important, in fact, the vital importance of section 84.2. And because of section 84.5, if the landowner obtains such a declaration, it is binding on the world. And that has certain consequences procedurally, which we'll touch upon in a second. But what it means is that if the landlord obtains that declaration, nobody can pop up in the future and say, well, actually, that was wrong. I had the benefit of the covenant, or the covenant means something different. So it does clear the title. I've done a number of these cases over the years. I did one earlier this year where my lay client wanted to bulldoze a rather smart, large detached house down in Cobham. There are lots of large and desirable houses, apparently, and build a block of 5 flats. And the neighbours who objected to the application for planning permission, which objections failed, were not too happy about this. For that reason, that's never really fully articulated why people don't like blocks of flats. And if I tell you that from the outside it looked like a house, that was a planning condition, or that was the development that was for which planning permission was sought, so it looked like a house. Anyway, they objected. But as a side wind, which so often happens, the neighbours said, well, Yabu, there's covenants on this title. You'll be in breach of the covenant. And the restriction provided that the landowner couldn't use the residence on the land hereby conveyed for any purpose other than that of a single private dwelling house. And the tenant said, a block of flats is not a single private dwelling house, and therefore you'll be in breach of covenant. I advised us 3 years ago now that was wrong as a matter of construction, reasons I needn't trouble you with now. But in order to clear the title, in order to be satisfied that was right before incurring costs, other than the planning costs which had already been incurred, the landlord made a claim under section 84.2 that the restriction which I've half read to you did not prohibit the building and use of a block of 5 flats. And as I say, that was entirely hypothetical. There'd been no development. But that's the essence of the jurisdiction under section 84.2. I should also add that there wasn't a copy of the relevant transfer which imposed this restriction. So 84.6 came to our aid, and we were able to say, well, the restriction is noted on the registered title of the land in the schedule of covenants in the usual way, and the court quite happily proceeded on the basis that that was the best evidence of the restriction and declared accordingly. Procedurally, it's a little tricky under section 84.2 because a declaration made operates in rem. It can be an application or claim can be made by any person interested, which obviously includes the owner of the relevant land, but also would include a contractual purchaser or indeed somebody who has the benefit of an option to acquire the land. And a number of my clients are developers who have options to take or to acquire land, and therefore want to understand whether they can proceed with the proposed development without having to exercise the option in the first instance. A far more difficult issue is who is the right defendants. The general rule is that anybody who arguably has the benefit of the restriction should be made a defendant, unless there's an unequivocal statement from that person that they have no right to enforce the restriction. And it's because the declaration made under Section 84.2 operates in rem that one should join all the defendants in order to satisfy the court, and this is where it becomes a little burdensome for claimants, in order to satisfy the court that all the potential enforcers of the covenant have been identified, the landlord, or forgive me, the landowner or the claimant will have to give notice to all those that its research has revealed as possibly having the benefit of the covenant. This is normally done by something called a circular letter in a pro forma. You send it to all the neighbours who might have the benefit of the covenant, telling them that this is what you want to do, and so on and so forth. This process can be burdensome and expensive. In the case I mentioned a moment ago that was concluded a couple of months ago, I think there were about 50 householders who possibly had the benefit of the covenant. And so the client my lay client had to deliver the circular letter plus a copy of the draft claim form, a copy of the restriction, a copy of the planning permission, and so on and so forth, and a response letter with a stamped address envelope, and so on and so forth. In a case I did under Section 84.2, the decision of the Court of Appeal was in 2012, so probably about 3 years before that. There were hundreds of potential beneficiaries of this covenant, and my lay client had to go through this process in respect of all those householders, which, as I say, was not a very is an expensive and burdensome exercise. Once a claimant receives responses to these circular letters, one can pick and choose who might be a defendant. It's usually those people who live next door or who make the most noise. They will be joined. A very useful procedural rule that helps a claimant in making a claim under Section 84.2 is CPR 19.6, which provides for representative parties to a claim. So what that means, without going into the detail of it, which is all set out in the paper, that if parties have the same interest in proceedings, or if persons have the same interest in proceedings, one of those persons or one or more of those persons can be joined as a party to the action, be it a claimant or a defendant, as representing all the others with the same interest. And I've set out the criteria which apply in the to the application of Section 19.6. And if one chooses, say, I usually go for four defendants who undoubtedly or arguably have the benefit of the covenant, then they can be joined as representatives of everybody else who's got the benefit of the covenant. Now, of course, anybody else who wants to be a defendant can join. Why they would, I would never know. I'll come back to that in a second. And so therefore the landowner doesn't have to join the 300 householders or whatever it might be. He or she can simply pick four, and who one picks, I repeat, depends upon who shouts the loudest and who most obviously would be adversely affected by the proposed use of the burden land. In the Coventry School Foundation case, the 2012 case that I mentioned, the details are contained in the paper. We chose four defendants. and the man who lived across the road was complaining a lot, and somebody who lived on another part of the land, and so on and so forth. Quite interestingly, in that case, that a local bigwig jumped up and said that he would take the place of two of the defendants. He had deep pockets. He lived about 1.5 miles away from the proposed development, so it wouldn't have impacted on him at all. But he was a local person, done very well, as I recall. Of course, if you want to be a defendant in a high court action, that may have certain consequences. In an important case, the University of East London against Barking and Dagenham, the benefiting land consists of 3,000 acres of residential development. In that case, the landowner was able to pursue persons unknown. So that's another means of avoiding the joining of all these persons. But the court must be satisfied that the landowner has taken all reasonable steps to identify and notify those with the benefit of the covenant. And after the claim is issued and it comes before the court, if the court is not satisfied that the landowner has taken such steps, then it'll give directions for the claimant to take further steps, and that could be advertisements in local newspapers or posters on trees and so on and so forth. But Section 19.6 is the way forward. I've never had a problem relying upon it, provided, well, in my cases, the clients have taken steps, I repeat, burdensome and expensive steps to ensure that they can be seen to have taken all reasonable steps to identify those with the benefit of the covenant. A declaration under Section 84.2 is a High Court claim, and it's got to be in the Chancery Division. There's no special provisions in the CPR that apply to claims under Section 84.2. The vast majority of claims will be a Part 8 claim, because there's usually no substantial dispute as to facts. What one does is a claim form setting out the declarations you sought, or the claimant seeks, together with a witness statement. This is just bog standard Part 8 claims. And the defendants have a right to put in evidence, again, in accordance with the CPR 8. It's usually, in the case of registered land, wise for the claimant to seek relief under Section 65 and Schedule 4 to the Land Registration Act, to have the entry in respect to the restrictions modified or removed from the title of the burdened land. The trial is before a High Court judge in open court, and the normal rules of evidence apply. Often the need for live evidence is dispensed with because, as I say, there's no inherent dispute as to fact. The case I concluded 2 months ago, there were no live witnesses. The facts were what they were. The land is burdened by this restriction. There's a house on it, and we want to put a block of flats on it. The planning permission allows us to do that. Will that be a breach of that restriction? So it's simply a question of arguing. In the Coventry School Foundation case, a case that was concluded in 2012, the defendant, supported by the local action group, took every point under the sun to satisfy the court that the proposed development would breach of a restriction, all the restrictions, and there were many burdening the land. It was a playing field. They want to put a school on it, on a small part of it, and therefore called lots and lots of evidence, because one of the restrictions was not to cause a nuisance or annoyance, and everything that we proposed to do on this land would be a nuisance and annoyance. And so they called everybody along the street to say how it would cause a nuisance and annoyance to them. And lots of evidence about small boys chasing hedgehogs and crisp packets and so on and so forth. So there was a lot of live evidence in that case. It lasted 2 weeks, if you can believe it. Often it's the case that the defendants don't appear at all. in the case that finished 2 months ago, the defendants, although they were very vicious about the proposed development, thought better of it and didn't turn up. But that doesn't mean that it's a shoo-in. The landlord, or sorry, forgive me, the landowner still has to prove his or her case. An important battleground in claims under Section 84.2 concerns costs. The normal rules as to costs in Part 44 don't apply to claims under Section 84.2, not because it's an express exclusion, but there's a jurisprudence that's been built up which says that it doesn't apply. The reason being is that the claimant is going to court to seek the assistance of the court to clear its title, and therefore it's unusual for the claimant to obtain an order for costs against the defendants who it's joined in order to achieve that desirable result. And that will be the case even if the claim succeeds. There's authority to support that proposition, and defendants in these claims often think that they can have a free day in court and indeed ask for the claimant to pay their costs. But one's got to be careful. In that Coventry School Foundation case that I mentioned that lasted 2 weeks, and ultimately the defendants lost in the Court of Appeal, and the Court of Appeal made an order for costs against them. The defendants, these are the 4 representative defendants, there might have been there was a fighting fund, but that's nothing to the claimant. That the claimant should get their costs from the date the claim form and the evidence was served on the defendants, because the Court of Appeal took the view that from that date, the defendants should have appreciated that they had no case. So there was quite a lot of pre-issue costs that were incurred by the landlord, but the clock started to run against the defendants from the date the claim form, or it might have been 2 weeks after the claim form and the evidence had been served. So there's a snapshot of Section 84.2 of the LPA, as I say, extremely valuable procedural and substantive provision, which allows one to have a definitive view from the High Court onto the impact, if any, of restrictions burdening freehold land. I can only speak to one more paper, and I've got to rush through that because our time is passing, and Norrie's probably already been knocked out, but there it is. The last paper I'm going to speak to is about surrender of leases. Again, this has been prompted by recent cases I've been involved in where the fact of a surrender of a lease has not been appreciated, and the consequences of that certainly have not been appreciated. Surrender of a lease is a means by which a tenancy is prematurely determined. I refer to it as a lease, but it mustn't be thought that it's a means of termination that only applies to formal leases of terms of years in deeds or in writing. Any tenancy can be determined by surrender. The main characteristic of a surrender is that it's a consensual act. There's got to be an agreement to express or imply between the landlord and the tenant in order to determine a tenancy by surrender, unlike a notice to quit served by a landlord or a tenant, or exercising a proviso free entry, or exercising a break clause. They are unilateral acts. To determine a lease by surrender, there must be a consensus between the landlord and the tenant. The means of surrender, there are 2 means of surrender. One is express surrender, and there's no magic in that. Occurs when the landlord and the tenant expressly agree that the lease should be surrendered and accepted respectively between the landlord and the tenant, or the tenant and the landlord, thus determining the leasehold estate. Every express surrender must be by deed or in writing. Leases for a term not exceeding 3 years at the best rent must be surrendered by writing signed by either the landlord or the tenant. All other surrenders must be by deed. Look at Section 52(1) of the LPA for the relevant provisions. There's no magic formula. The precedent books are full of deeds of surrender. There's very little with them, little to them. Where the lease is registered, the deed can be produced to the land registry and the relevant leasehold title closed. That's easy for you to say. The second means of surrender is surrender by operation of law. This is far more controversial and interesting. This means of surrender occurs when there is no express agreement between the landlord and the tenant, but operates by law. Notwithstanding that there's no express agreement, the nature of the surrender, namely a consensual act, remains extant. The consent being deemed from the objectively observed acts of the party. So there's a surrender by operation of law where the tenant redelivers possession of the demised premises to the landlord, and the landlord unequivocally accepts the delivery of the premises. The law implies a surrender from the conduct of the parties, which is inconsistent with the continuation of the tenancy, provided that the actions on both sides is unequivocal. As I've said, this doesn't have to be in writing or by deed, but the actions relied upon must be unequivocal. Delivery up of the keys to the landlord is a textbook, an acceptance of those keys by the landlord is a textbook example of an implied or surrender by operation of law. But simply, the tenant simply putting the keys to the landlord's letterbox or bringing them round or posting them or leaving them with their agent is not enough, because that doesn't, it's not evidence of consensual acceptance of the surrender by the landlord. The landlord might take the keys and hold them for safety reasons. The landlord might even enter the premises in order to secure them, but that's equivocal and therefore will not constitute an acceptance by the landlord. The burden of proof is on the party alleging that there's been a surrender to prove that that is the case. The surrender by operation of law is not dependent upon the intention of the parties, because there are often surrender by operation of law where the parties haven't directed their minds to a surrender, notwithstanding that it's a consensual act. The most common example of where that arises is where the parties to the landlord and the tenant, if you like, rearrange their legal relationship. The most common example is where the parties to a lease vary the terms of the lease. Depending upon the nature of the variation, there can arise in those circumstances an implied surrender or a surrender by operation of law. I've set out the relevant principles at some tedious length in the paper, but it boils down to this, that if the deed of variation purports to add land, increase the size of the demised premises, or if the variation purports to increase the term vested in the tenant, there will be an implied surrender of the existing lease by operation of law and a regrant. It is really quite as simple as that in my view. In a recent case, very small case involving a small flat somewhere in South Essex. My client wanted to buy a lease of a flat and was concerned about the obligations to repair the structure and exterior of the building. The lease my client wanted to buy was made in 2002 and was expressed to be a deed of variation of a lease granted in 1971. The 1971 lease was a tripartite lease where a management company had obligations to repair the structure and the exterior. The deed made in 2002 extended the term, but lo and behold, the management company wasn't a party to it. And although the 2002 deed purported to reproduce the 1971 lease within its terms, of course, it couldn't reproduce a covenant by a party who was not a party to it. The long and the short of it was that meant that in 2022, there was nobody who had covenanted or was, but the landlord had been doing it on an informal ad hoc basis, and you might imagine that or can guess that the landlord was owned by the tenant, so there wasn't a problem with that on a practical level. But my client's funder was particularly concerned about that. The landlord's or the vendor's solicitor took the view that we were talking nonsense, and he would say that, wouldn't he? It was a he. But we wouldn't budge, and therefore he said, well, I'll solve the problem by getting insurance. And of course he couldn't. The point there is that the 2002 deed, which extended the term granted by the 1971 lease, operated as a surrender and regrant, and on the regrant, the covenantor, the management company, wasn't a party, and therefore there was nobody who had covenanted to repair the structure and the exterior of the building, and therefore there was a telling gap in the repairing obligations with respect to the building, and so my client bought a flat in the block next door, or something like that. As to the effect of surrender, as between the landlord and tenant, it vests the leaseholder's estate in the immediate reversioner and brings to an end from that vesting the ongoing liabilities of the landlord and the tenant under the lease. That includes obviously the obligation to pay rent, repair, and so on and so forth. Of course, if the parties make express, if the surrender is by an express surrender, the parties can make a condition of surrender whatever they like. But in the context of implied surrender, the obligations going forward come to an end, but pre-existing causes of action are not affected. More significantly, not significant, is the effect of surrender on subtenants and mortgagees. This is the principal difference between surrender and other means of terminating tenancies. And again, put simply, the impact of surrender is that it doesn't impact on the interests of subtenants or mortgagees. And a fairly recent case of Barrett and Morgan in 2000 sets out in the speech of Lord Millett in his typical clear fashion what the impact of surrender is on subtenants and mortgagees. And I repeat, it's simply not to bring the interests of a subtenant or mortgagee to an end. Well, you might say, well, then hang on a second, if the lease goes, who's the landlord of the subtenant, and so on and so forth? Well, it's all dealt with now by sections in the Law of Property Act 1925. I set the relevant provisions out in the paper. We're concerned with section 139(1) of the LPA and section 151, and 150 subsection 1, that is. So it's 139 and 150, which make provision for the, if you like, stepping into the shoes of the mean landlord's obligations in respect to the subtenant when the mean tenancy has been surrendered. That brings us to the end of the 90 minutes that we've had. I haven't spoken to the paper on repairing obligations, but you have it or will have it soon. It's not quite as fun as getting on the train and coming down to see you all, but maybe going forward, or perhaps this is inevitably we'll do it this way if I'm invited back to do it again. But thank you very much for attending this afternoon. I hope there's something there of interest, and have an enjoyable evening. Goodbye now.